Welcome to Law and the Machine, where artificial intelligence meets the legal system, liability, regulation, intellectual property, and the government's uncomfortable role as both rulemaker and AI adopter. The law wasn't written for this.
The Pentagon's Project Maven, an initiative to use artificial intelligence to analyze drone footage, became a flashpoint when Google employees protested the company's involvement. But beyond the public outcry, the deeper issue concerns how the lines blur when the government acts as both the primary customer for advanced AI systems and the ultimate rulemaker for those very technologies.
And that blurring isn't just about ethical concerns from employees. It points to a structural tension. When the government is essentially saying, we need cutting-edge AI, but please don't tie our hands with stupid rules about how we develop or deploy it, it creates a massive accountability gap.
So the very entity that should be overseeing these powerful technologies is also incentivized to accelerate their adoption, sometimes in areas as sensitive as military targeting. It's a fundamental conflict.
Exactly. And the phrase, no stupid rules, isn't just a flippant remark. It reflects a mindset that can sideline critical legal and ethical considerations, especially when speed and capability are prioritized above all else.
Project Maven really did bring that into sharp relief. For listeners who might not recall the details, the core idea was to use machine learning to identify objects in video feeds from drones, essentially automating parts of the targeting process for the military. Google's initial involvement sparked significant internal dissent, leading to the company ultimately deciding not to renew its contract.
That internal protest was crucial because it highlighted a tension that often remains invisible. Google was helping build tools that could accelerate drone strikes, and employees raised ethical flags about the use of AI in lethal applications, especially when human oversight might be diminished. The company's public commitment to AI principles clashed directly with the realities of a lucrative defense contract.
So it wasn't just about if AI could do it, but should it? And who was asking those questions within the government itself when the contracts were being drawn up? This brings us to a phrase that comes up in discussions about these programs: missing lawyers.
The concept of missing lawyers refers to the apparent scarcity of legal and ethical expertise embedded within the AI development and procurement processes, particularly in defense and intelligence. When the focus is on rapid technological advancement and achieving operational superiority, legal and ethical review can be perceived as an impediment rather than an integral part of responsible innovation.
It's like building a bridge without consulting structural engineers on the legal team about the long-term liabilities or the codes of conduct that apply. The project moves forward, but the foundational legal and ethical frameworks aren't being built in from the ground up.
That's a precise analogy. In the context of Project Maven, for instance, the technical teams were highly skilled in developing the AI algorithms, but the crucial questions about international humanitarian law, rules of engagement, or the potential for algorithmic bias in identifying targets, those considerations can be overlooked if legal counsel isn't integrated early and deeply into the design process.
And this isn't just a problem for defense contracts, is it? Similar patterns are observed in other government agencies that are adopting AI. When the government becomes a major purchaser, does that also impact its role as a regulator?
Absolutely. This is the heart of the conflict docket. When the government is spending billions on AI solutions from private companies, it develops a vested interest in the success and growth of those companies. That financial relationship can subtly, or not so subtly, influence regulatory policy. For example, if a department is heavily reliant on a specific vendor's AI system, it may be less inclined to impose strict regulations that could impede that vendor's operations or increase costs.
So the government isn't just a neutral arbiter setting rules from a distance, it's a deeply engaged consumer, and that consumer relationship can make it difficult to be an objective regulator.
Exactly. Consider the pressure to innovate quickly in areas deemed critical for national security or public service. There's often a temptation to adopt a move fast and break things mentality, which clashes with the meticulous, risk-averse nature of legal and ethical review. The no stupid rules mantra becomes a convenient way to justify bypassing what might be seen as bureaucratic hurdles.
That sounds like a recipe for regulatory capture, where the industry effectively writes its own rules, or at least heavily influences them under the guise of collaboration or necessity.
It certainly creates conditions ripe for it. When government agencies look to industry for expertise on how to regulate AI, the advice they receive will naturally align with the interests of the companies providing that advice. It becomes a cycle where the very entities that need to be regulated are helping to define the regulatory landscape. This isn't necessarily malicious. It can simply be the path of least resistance when expertise is concentrated in the private sector.
And what are the long-term consequences when this happens, especially for accountability? If a mistake or harm occurs due to an AI system procured by the government, who shoulders the blame? Is it the government for procuring it, the company for building it, or is the responsibility diffused?
That's the critical aha moment for many observing this space. The accountability framework often struggles to keep pace with the technology. When AI systems make decisions that lead to adverse outcomes, whether in military targeting, predictive policing, or social services, the chain of responsibility can be incredibly complex to untangle. Was it a flaw in the algorithm, an error in how the data was collected, a misapplication by the user, or a policy decision that greenlit the system without adequate safeguards?
It essentially creates a new kind of liability vacuum, where the legal system hasn't fully evolved to assign blame or ensure redress for harms caused by autonomous or semi-autonomous systems. And if the lawyers are missing during development, that vacuum is only going to widen.
Precisely. The lack of proactive legal and ethical integration means that these questions often only arise after something has gone wrong. And by then, the systems are deeply embedded, making retrofitting accountability measures much more difficult and costly. It leaves the public in a vulnerable position, relying on systems that may lack transparent oversight or clear pathways for recourse.
So, to reiterate the core tension, the government acts as a massive AI customer, pushing for rapid adoption, potentially with a no stupid rules mindset. There is a perceived absence of comprehensive legal and ethical review in the early stages, often referred to as missing lawyers. The result is a significant accountability gap.
That is the nexus. The government's dual role as both a primary driver of AI innovation through procurement and the ultimate arbiter of AI ethics and regulation creates a systemic conflict of interest. This makes it challenging to establish robust, independent oversight and ensure that public interest, especially concerning safety, privacy, and fairness, is genuinely prioritized.
For listeners, one key takeaway from cases like Project Maven is that the ethical implications of AI are not separate from its technical development. They are intertwined. The question of whether something should be done needs to be asked alongside the question of whether it can be done from the very beginning.
And another insight is that regulatory capture doesn't always manifest as overt corruption. It can be a more subtle process where the concentration of expertise and resources within the private sector naturally leads to industry-aligned policies simply due to the government's reliance on those same entities.
Finally, the absence of robust legal and ethical frameworks from the outset creates a vacuum that can have profound long-term implications for public trust and accountability, especially when these systems are deployed in high-stakes environments.
The crucial question, then, is how to cultivate genuinely independent legal and ethical oversight for government-procured AI, especially when the government is simultaneously one of the technology's biggest cheerleaders and customers. How can those missing lawyers be not just present, but empowered?
That's all for Law and the Machine. Join us next time as we continue exploring where AI and the law collide. If you found this useful, subscribe. We appreciate it.
The law will catch up, eventually.